Trademarks. These are the kind of brands that we see around us all the time. There are 4 registered trademarks at the bottom of this slide. Universities take their trademarks very seriously these days because they wouldn't want another institution somewhere else trading off their good name and potentially damaging their good name. It can be logos, words, combinations. Once you've got a registered trademark, you can add that circle R symbol next to it. But it's important not to be just strewing these throughout your work willy-nilly. Use of the circle R is an offence if you don't actually have a registered trademark. The benefits to somebody of having a trademark are, of course, that they can develop some value in their brand, and you can stop other people using your mark and potentially damaging your brand. And again, it makes it easier to take legal action if somebody tries. They've got to be distinctive. Again, going back to the 4 trademarks on the bottom of here for the universities, very different from each other, and this is important. If your trademark looks a little bit like somebody else's, it will probably be rejected. In terms of length of protection, these are the greatest of all of the intellectual property rights. Theoretically, you can keep a trademark in perpetuity as long as you keep paying. You have to renew every 10 years for trademarks. If it's just a description, that will automatically be excluded. It has to be something that's clearly a name for your product. Something that just describes shiny black shoes is not going to qualify as a trademark, partly because it lacks distinctiveness. Another issue as well is if it becomes a common usage or something customary in your line of trade. So both Hoover and Google have had concerns about this over the years. It's essentially a bit of common English usage to say I'm going to hoover the carpet, and when what you mean is I'm going to use a vacuum cleaner on the carpet, because Hoover is a trademark. And Hoover were in danger of losing their trademark at one point because of this. They managed to fight numerous expensive legal actions and retain it. The same's true for Google. It's got to the point where you don't talk about performing an internet search for something, you say, I'll Google it. And Google also got very worried about losing their trademark, and in fact, I think they started writing lawyers' letters to TV presenters who were using the phrase Google it to tell them to stop, because it was threatening their trademark.